You're watching the legal breakdown. Glenn, some major news out of the 11th Circuit Court of Appeals where they delivered a major rebuke to both Trump and a Trump-aligned federal judge, and that was in the Mar-a-Lago case. Can you give an overview of what happened in this case?
Yeah, so not to bury the lead, Brian, the 11th Circuit Court of Appeals, three judges unanimously just smacked down Judge Aileen Cannon, the Trump-appointed judge that, did something, according to the 11th Circuit Appeals Court, that she had no lawful basis to do. The court said she should not have exercised jurisdiction over this case. She should not have appointed a special master to review all of the documents that the FBI lawfully seized from Donald Trump at Mar-a-Lago, and she certainly should not have paused or stopped the FBI criminal investigation into the theft and unlawful concealment of those documents. So it was really a blistering rebuke of federal judge Aileen Cannon.
So basically, we know now that she didn't follow the law as it was written. What happens to a judge in that case? Like, what happens when a judge with a lifetime appointment basically disregards the law that she's charged to uphold?
That's a great question because, some of what the 11th Circuit Court of Appeals said is just because the search was conducted on the home of a former president does not give the federal court or any federal judge the authority to stop an ongoing criminal investigation. Make no mistake about it, Brian. What the appellate court said was that Judge Cannon inappropriately, unlawfully stopped a pending federal court investigation, and not just any investigation, an investigation that has serious national security implications because of the nature of the documents Donald Trump stole from the White House and unlawfully kept at Mar-a-Lago. So what happens to Judge Cannon now that the appellate court has made this finding? I am sorry to say, probably not much. There are only two things that can happen to a judge who is found to have been involved in unethical conduct or judicial misconduct of some kind. They can be impeached. What would that involve? Well, the House of Representatives would have to investigate, would have to vote on articles of impeachment, and if passed, would have to send them over to the Senate for a trial to see if Judge Cannon should be convicted on those articles of impeachment and removed from the federal bench. But with the House of Representatives about to fall into Republican control,
Right.
What are the odds? They're going to hold a Trump-appointed judge who did a favor, though, for Donald Trump, hold somebody like that accountable. I think the odds are slim to none, and slim is fading fast. What's the other thing that can be done when a judge is found to have, involved themselves in ethical misconduct or other kind of judicial misconduct? Well, there is a committee. There's a judicial tenure committee that receives complaints about judicial misconduct and investigates. People may not know that anybody can file a judicial complaint form. You don't have to be a party in the case. If you become aware in any way that a federal judge has engaged in possible misconduct, you can go to uscourts.gov and you can fill out a very simple page-and-a-half long judicial misconduct complaint form. And then it goes to a committee that investigates it. Now, that committee, even if they determine the judge did engage in professional misconduct, can't remove the judge from the bench, can't fire the judge, can't reassign the judge, but can impose certain sanctions, a reprimand, and can report out their findings to Congress to the extent Congress thinks it's necessary to then take up the matter from there.
Right, which given the fact that half of Congress is actually a party to this exact issue at hand, I wouldn't exactly hold my breath if they're going to do anything about it, especially given that in the House, Republicans are going to retake the majority. So with that said, I guess how does she justify, Judge Cannon, how does she justify handing down a decision basically granting this special little carve out to Donald Trump solely because he was the president and for no other reason? Like, isn't this as clear evidence as you can get that she's just putting one person above the law, that she's not subscribing to equal justice here?
Yeah, interestingly, she doesn't even try to find some legal authority to cite or in support of her decision. When you read her rulings, she basically said, president's unique. A former president deserves some sort of special procedures and safeguards that mere mortals, like all of the rest of us, are not entitled to. She doesn't even really try to ground it in some sort of legal precedent. She just said, listen, I think he deserves a little extra protection. So I'm going to order that a special master of my choosing be put in place to review all of the evidence of crime that the FBI seized from Mar-a-Lago, from Donald Trump, in accordance with a lawfully issued federal search warrant. That, I think, is what caused the 11th Circuit Court of Appeals to rebuke her in the strongest, most direct language. And, you know, the appellate courts usually don't talk like that. And what I would do is urge everybody, Brian, to read at least pages 20 and 21 of the 11th Circuit Court of Appeals opinion. It's just a few paragraphs, but I'm telling you, maybe I'm an appellate geek, but to me, it sounds like about as close as rule of law poetry can come. It really is beautifully crafted. It is strong, direct, stinging language, and it really does help restore my faith a little bit in the rule of law and in the federal judiciary, because here is another little bit of silver lining behind the big black cloud that, you know, seems to consume us anytime we're talking about the crimes of Donald Trump.
Yeah.
The three judges who just reversed Judge Cannon's ruling, all three are Republican appointed judges. Two of them were appointed by Donald Trump himself. So what does that tell us? It tells us that notwithstanding Mitch McConnell and Donald Trump's nefarious attempts to cram unqualified judges down the throats of the American people, they have failed to destroy the federal judiciary. They've done some harm. They've appointed some judges that the American Bar Association rated as not qualified. And as an aside that I feel compelled to add, do you know when President Barack Obama was contemplating who to appoint to the federal bench, you know what he would do? He would ask the American Bar Association to rate the person: qualified, fully qualified, well qualified, not qualified, before he made his final decision. And every single time the ABA rated one of his potential selections not qualified, Barack Obama did not nominate that person. You know what that is? That's not politics. That's just good government, honest, ethical government, but not McConnell and Trump. Oh, the ABA said this person is not qualified to serve in a lifetime position on the federal bench, judging the cases involving us mere mortals. We don't care. They are ideological right-wing zealots, and we're putting that unqualified person on the bench. This has given me considerable heartburn as a former career federal prosecutor who really does value the quality of our judiciary that McConnell and Trump tried to destroy, but they didn't succeed, Brian. They didn't succeed because two of the three appellate court judges just ruled in the most direct way against Donald Trump's interest.
You know, while we're talking about Judge Cannon, they really did get their return on investment on her, because had they gotten someone who was qualified, she wouldn't have gone out of her way to protect the guy who appointed her for the reason that she was unqualified. So in a way, like, he did get exactly what he wanted in Judge Cannon. With that said, you know, we have watched over the last few years as even Trump-appointed judges have rebuked Donald Trump. Obviously, for the whole big lie election theft scheme, we saw, I believe, 9 Trump-appointed judges side against Trump and his allies. Have you found that generally these people have an allegiance to the law over Trump?
Generally, they do. Even, you know, the example we just discussed, 2 appellate court judges on the 11th Circuit just ruled hard against Donald Trump's interests. So some of these Trump-appointed judges are proving to take their oath of office seriously. Then there are other judges who, in my estimation, have not taken their oath of office seriously. I'll use as an example a former federal prosecutor from my old office, a judge named Trevor McFadden in federal district court in Washington, D.C. Judge McFadden sat on the case involving the Congress's attempts to get Donald Trump's tax returns. He sat on it for 3 years. No reason, no excuse. And that, I think, is a real problem. Another Trump-appointed judge, Judge Carl Nichols. Judge Nichols presided over the Steve Bannon trial. I was in court watching the entirety of that trial. And here's what I'll say. Judge Nichols actually presided fairly, independently, honorably over that trial. He called balls and strikes. I tended to agree with the majority of his calls, but the ones that I disagreed with were within what I would call the margin of error. But then when it came time to sentence Steve Bannon for his crimes against the United States, against the Congress, because he thumbed his nose at a congressional subpoena, said, I ain't coming, I ain't testifying, I ain't providing documents. And Judge Nichols not only went extremely light on the sentence, he then is allowing Steve Bannon to remain at liberty in the community, at home, not even under house arrest, pending his appeal, which I can tell you, unfortunately, Brian, could take years. Let me tell you, if Steve Bannon were not a rich, white, male, influential, connected character, if he were poor, if he were a person of color, oh, he would be sitting in federal prison right now. That is a grave injustice. I would call it an obscenity that Carl Nichols did not make Steve Bannon go to jail for the conviction that he so richly deserves.
Now, going back to Judge Cannon for a moment, I'm assuming that it's uncommon to get publicly shit on by a high-profile court in a high-profile case like this. But given how much of a partisan hack Judge Cannon is, does she just basically become a pariah in the judicial community? Like, what is the legal world going to be like for her among her colleagues?
So the legal world in each jurisdiction is typically a pretty small community. Judges talk to one another about their fellow judges, how they're performing. Judges talk to one another about prosecutors, about defense attorneys. And let me tell you, prosecutors and defense attorneys talk about each other, and we talk about judges. And once the legal community learns that a judge has done something unethical, has engaged in misconduct, that's kind of a scarlet letter that judge will wear for the rest of his or her life. Now, maybe it matters to the judge himself or herself. Maybe it doesn't. But I can tell you the legal community will never look the same at somebody like Judge Cannon, who the appellate court just told us did something that had no support, no basis in the law, in precedent. She did a favor for Donald Trump, the president that had just appointed her to the bench. And that really, it just so degrades the federal judiciary that I don't believe she can recover from that. She may not be interested in recovering from that. She may just go on her merry way, thinking she tried to do a solid for the president that appointed her, and maybe she is comfortable with that.
And does that matter in that world? And I ask for a little bit of like inside baseball here because, I used to be in the entertainment industry. That's all networking. It's all your colleagues. That's everything. If you think that people are getting booked solely because of talent out here, you're missing a big part of it. But in that world, in the legal world, does your standing among colleagues, does your standing in the community really have an impact?
It should matter. I don't know how much it does matter.
Yeah.
She has a lifetime appointment. So What does that mean? She will be paid with our tax dollars for the rest of her life, as long as she's on the bench, notwithstanding how she was just smacked down by an appellate court for basically acting in a lawless way by exercising jurisdiction in a case she had no right to exercise jurisdiction in. It should matter. I don't know that it does matter. I don't know that it matters in the judicial assignments she will receive in her time on the bench. So I'm afraid that she's probably gotten away with it. And to the extent it doesn't weigh on her conscience, then I don't know what other repercussions there might be.
Just building off of that for a moment, is there a certain person who assigns these cases, and would how she comported herself in this scenario have any impact on how she's assigned cases in the future of national significance?
So the answer about federal case assignments is an interesting one. There's something called the wheel. It's a figurative wheel, not a literal wheel. And I know this because I know lots of the judges in the courts of Washington, D.C. Some of them I supervised, some of them I tried cases with, some of them I tried cases against because they're former public defenders, and they are by and large excellent jurists. There is a wheel, and the judges' names appear in order on that wheel. And literally every time a new case comes in, the wheel turns one click, and the next judge who's up on the wheel catches the assignment. I will tell you, this sometimes engenders some frustration in the judges, because some judges end up getting, for example, none of the high-profile cases, none of the J6 cases, none of the seditious conspiracy cases. They get a bunch of, civil law disputes that, frankly, are a little bit less interesting and certainly low profile or no profile. I think the judges all kind of take it as part of their duties, but it is supposed to be, and I trust the system in this respect. I think it is a completely random system of assigning cases. I don't think they try to find the right judge for the right case because of the judge's temperament or disposition, or worse, sort of ideological preferences.
Okay, so let's switch topics completely here to Kellyanne Conway. She testified for the January 6th committee for 5 hours. You've spoken at length about how Kellyanne resigned not long after Trump made it clear that he wasn't going to accept the election results. Why do you think that that's significant? Like, how does that put her in a different position from her former colleagues? Yeah,
so Kellyanne Conway, she of Alternative Facts, sat for a 5-hour interview with the January 6th House Select Committee investigating the insurrection. And some people have observed, well, she left the administration before the election. So how could she have anything relevant to add to what Donald Trump did to try to overthrow our democracy? But there's a really important data point, at least from the perspective of this old former career prosecutor. Donald Trump, for the first time, expressly stated that if I lose the election, it will be because the election was rigged. He first stated that on August 17th, 2020, a couple of months before the election. And Kellyanne Conway, who really did seem to covet her position as senior counselor to the President of the United States, once he said that, she resigned. Now, she resigned on August 30th, just a couple of weeks after Donald Trump made what was a pretty horrific announcement for a sitting president to make. If I lose, it's because the election is rigged. She got out of town. Okay, we know that she got out of town, but we don't know why she got out of town. And that is something that I think is of keen interest to the January 6th committee. And I can promise you, Brian, that it will be of even keener interest to the federal prosecutors that put her before the federal grand jury to testify about all things Trump and insurrection. The other thing that I have always sort of had in the back of my mind about Kellyanne Conway, she wrote a book. I didn't read it, but I read the New York Times review of it. And they reported that Kellyanne Conway, in her book, wrote that in the sort of waning hours of the Trump administration, Donald Trump ambles up to her and says, and I'm going to quote the word she used in her book, "Honey, you want a pardon? Everybody needs one." And Kellyanne Conway in her book said, Mr. President, I don't think I did anything wrong, so I don't think I need a pardon. And she reports that she declined the president's offer of an unsolicited blanket pardon. What does that tell me? Well, do we really think Kellyanne Conway was the only one Donald Trump ambled up to and offered an unsolicited blanket pardon? No way. You know that there are going to be close associates, criminal associates, co-defendants, and family members, and there's a good bit of overlap in those categories, who probably were offered pardons by Donald Trump. I'll bet some of them accepted those pardons, but we're not going to know any of that because there's no law, there's no provision in the Constitution that requires that these pardons must be recorded somewhere or must be disclosed publicly in order to be valid. There should be a law. There should be, rules in place to prevent this sort of thing from happening, but there aren't. There are protocols, but the president is free to disregard them because the only constraints on the presidential pardon power are embodied in the Constitution itself. And there are only two limitations. One, a president can only grant pardons for federal crimes, not state crimes. And two, a president cannot use a pardon to get somebody out of an impeachment, except in cases of impeachment. So if somebody is impeached, tried in the Senate, convicted, and removed from their office, the president can't use a pardon to undo that impeachment. But for that, the presidential pardon power is pretty wide open. So we have to wait and see, Brian, once the indictments begin to drop, if some of these characters who were close to or perhaps related to Donald Trump begin pulling pardons out of their pockets and saying, hey, you can't go against me. I've got a presidential pardon.
But what happens in the situation where if you have a criminal president who is, conducting some criminal behavior and he basically grants a pardon to a criminal accomplice within his administration, is that pardon still valid? And how do we litigate something like that? How do we determine if that pardon was even counts to begin with?
That's a great question. And we actually have a concrete example, I believe, of Donald Trump delivering a corrupt pardon to a criminal associate, Roger Stone. Let me answer the first question. How do we litigate that? Well, we challenge it in court. So if Roger Stone, for example, gets indicted for something and he produces yet another pardon out of his pocket, we have to litigate it. We have to challenge the legality and the validity of a pardon like that. Let me use the Roger Stone example to kind of highlight what a corrupt pardon looks like, what an unenforceable pardon looks like. Remember that when Roger Stone was called before Congress to testify about all things Trump, Russia, he lied and he lied and he lied and he lied. Therefore, he was indicted for 7 counts: false statements to Congress, obstruction of justice, tampering with a witness. Donald Trump sent the message out very publicly in posts on Twitter and said, don't snitch, don't snitch. Snitches are bad. Don't break, don't go against me. And Roger Stone didn't. Roger Stone obeyed those obvious commands from Donald Trump. He went to trial. I was in court, watched the whole trial. He was convicted hands down because he had committed all those crimes, and the government proved it beyond a reasonable doubt. And then he was sentenced to 40 months in prison by Judge Amy Berman Jackson. 3 days before he was to report to the Federal Bureau of Prisons to begin serving his 40-month sentence, he gave an interview. What did he say in that interview? Mr. President, I stayed strong for you. I didn't snitch. It would have been much easier on my family if I had cooperated with the prosecutors, but I didn't. Now, you know what I want? I want a sentence commutation. And later that day, Donald Trump commuted his sentence, so he didn't have to report to prison. And thereafter, as we know, he gave him a full pardon. What I just described, Brian, is actually a criminal offense in and of itself. It's obstruction of justice, and it's a conspiracy to obstruct justice between Donald Trump and Roger Stone. That cannot stand. That cannot go unaddressed. The Department of Justice needs to pick that mantle up and needs to challenge that pardon, in my estimation, to make sure that the next corrupt president can't do it all over again.
Right. Okay, let's finish off with this. January 6th committee is making all transcripts public, and that includes transcripts from, I believe, over the 1,000 interviews that they've conducted with those who were involved in the events of January 6th. Once that happens, obviously there's going to be a mad rush, to dig into the details of all of these transcripts. Which transcripts are you most interested in?
Yeah, which transcripts am I not interested in? There are more than 1,000. And I don't even think we have any idea who all has been interviewed by the J6 committee. I know there's one that I wish had been developed by the J6 committee, but wasn't, and that was Vice President Mike Pence, because he, frankly, is one of the most important fact witnesses in the whole shebang. He was the one against whom Donald Trump launched a pressure campaign to get him to violate the law, the Electoral Count Act, right? Trying to get Mike Pence to corruptly throw the election to Donald Trump. And Mike Pence said, I will not testify. Congress is not entitled to my testimony. What a guy. I wish that one, you can tell that one sticks in my craw. I wish that one had been developed by the J6 committee. I can promise you it will be developed by the federal prosecutors inside the grand jury, because, you can close the door on congressional testimony. You can't close the door on grand jury testimony until you're inside the grand jury room testifying. Then they'll close the door. So, I think there are so many transcripts that have been developed. That is going to be a huge undertaking by the federal prosecutors to review them all. Now, remember, the federal prosecutors have already put in the grand jury lots of the folks who testified before the J6 committee. But now what they're going to have to do is take a step back. They're going to have to compare the grand jury transcript to the J6 committee transcript. They're going to have to assimilate the two to make sure that they're consistent. And if there's something that witnesses said before the J6 committee that the federal prosecutors need to follow up on or develop more fully, that is going to be the task. I hope they're up to the task. It's going to be a mammoth undertaking. But, I think at the end of the day, there's going to be this incredibly complete record of Donald Trump's criminal attempts to overturn our democracy.
Yeah, obviously a lot more to come. So we'll leave it there. Thank you, everybody, for watching The Legal Breakdown. Make sure to subscribe to both my channel and Glenn's channel here on YouTube so that you don't miss the next episode. Both of those links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.